decision to charge the accused was based.
Yeah, okay.
As it pleases the court, my lord. It is so that we have a docket, but there is nothing wrong in me while serving that docket to request this witness to give that factual basis or to give the facts on which he approached the NPA. This is cross-examination. The state cannot simply assume.
You know what, I'm going to overrule you. I just read 179. Just read what 179.
Then I'm not going to proceed.
Yeah.
Just read 179.
Well, the heading says prosecuting authority, section 179, subsection 1.
Yes.
There is a single national prosecuting authority in the Republic, structured in terms of an Act of Parliament and consisting of a National Director of Public Prosecutions, who is the head of the prosecuting authority and is appointed by the President as head of the National Executive, and B, Directors of Public Prosecutions and prosecutors as determined by an Act of Parliament, subsection 2. The prosecuting authority has the power to institute criminal proceedings on behalf of the state and to carry out any necessary functions incidental to instituting criminal proceedings. I think that's what the court has just referred to. Subsection 3, national legislation must ensure that the Director of Public Prosecutions, subsection A, are appropriately qualified, B, are responsible for prosecutions in specific jurisdictions, subject to subsection 5. Then subsection 4, national legislation must ensure that the prosecuting authority exercises its functions without fear, favor, or prejudice. Subsection 5, the National Director of Public Prosecutions, A, must determine with the concurrence of the cabinet member responsible for the administration of justice and after consulting the Directors of Public Prosecutions, prosecution policy which must be observed in the prosecution process. B, must issue policy directives which must be observed in the prosecution process. C, may intervene in the prosecution process when policy directives are not complied with. And D, must review a decision to prosecute or not to prosecute after consulting the relevant Director of Public Prosecutions and after taking representations within a period specified in the National Director of Public Prosecutions from the following: Roman figure 1, the accused person; Roman figure 2, the complainant; Roman must exercise final responsibility over the prosecuting authority. And lastly, subsection 7, all other matters concerning the prosecuting authority must be determined by national legislation. That is the sum total of section 179.
Yeah, you can answer that if you think you can. But what the law says, there has got to be litis constantatio before a person can be charged in a court of law. In other words, the accused himself must plead. And when he pleads not guilty, then that is the commencement of the case. And if the accused or his counselors believe that these charges are frivolous or they are brought for a malevolent reason, then he brings an application to court for the judge to decide whether in fact there is evidence, prima facie evidence upon which a person may be charged. So even Batohi doesn't just read. He inspects the docket, he goes to the law because this is what guides him. And only after that does he charge a person. And the law specifically say a director of prosecutions may not charge a person if there is no sufficient compelling reason. Okay, you can answer Mr. Nisi if you are able to. That's what the law says.
May I just assist the court, my lord?
No, you don't assist me, please. I've told you what the law is. Don't assist me.
No, I'm not.
If I'm wrong, take me on appeal, take me on review, fine. But I'm saying this witness, you can cross-examine him on that very aspect.
Thank you, my lord. Thank you. Thank you, Brigadier. I said I'm requesting the facts that you presented to the Office of the Director of Public Prosecutions, on which you are requesting them to make a decision on these accused persons. Thank you. You say, in respect of accused number 1, you had evidence of a confession, you had evidence of a pointing out, you took statements from witnesses, and what else?
Bayacela ukuthi azike lapho lapho kakade bekhuluma malana nezomthetho ke ngesikhathi malana nenkulumo kammeli le bayiqhamukisileke bese umnumzana advocate Bhalo bese wafunda ke malana nesigaba lesi somthetho esahambisana nalo daba lo kade inkosi enkantolo idikida ke futhi nommelweni ke lapho ke bese inkosi enkantolo athi kulungile ke ummeli angaqhubeka abuze ke lo mbuzo ke lana ke uyamvumela ke ummelweni ke manje ecela ukuthi ufakazi ke aphendule ke malana nodaba lo kade noma malana amaphuzu la kade anawo ke amaphuzu lawo ke la khona ke amlekelele ekuthizeni bakhona begcina kuthwesa ke umsoro oqala ke icala lapho ke bese wakhuluma ngodaba lo confession udaba lama statement ofakazi futhi udaba lokuthi ade ikhonjiwe yona ke lapho.
My lord, so with greatest respect, previously, even on the trial, within trial, and subsequently on the trial, when I was busy, particularly under cross-examination, I dealt with the evidence that connects all the accused. And that is found because I was referred to various statements, but the statement which contains the facts, the evidence that I have on each of the accused, I was made to read it in court, and it summarizes all the evidence, and that is A198. That is the application for the warrant of arrest of accused dated the 23rd of October 2020. Under each accused, the facts, as Advocate Nisi says, it needs the facts of what evidence did I have. That is a summary of it, although I was directing it to the courts, but it was emanating from the docket, not from me, and it is the facts that I presented to the DPP. Now, if I have to be specific as to point by point what is contained, it means I must go through this statement. I've dealt with it.
Go through it again.
Athi ke lapho ke bayadaba lolu ke ummelweni ke banomzana ke buza ngalo ke malana nodaba lamaphuzu lawo kade una ke anawo futhi omikise kuthimba la hlangothi lezabashushisi ekuthizeni abashushisi abakhulu bese bathatha ke isinqumo ke lapho ke sokuthi yebo asibathwese icala lesigameko lesi kade misolwa ukuthi nisenzile ke lapho ke udaba lolu wakhuluma ngalo ke la enkantolo ngesikhathi icala ngihlelwe phansi likhulunywa le enkantolo noma beliqala enkantolo futhi obuya ukukhuluma ngalo lo daba lolu ke ngesikhathi kade bembuza ke imibuzo ngaphakathi ngesikhathi kade kunomzila ngaphakathi komzila noma ngesikhathi kade kukhona nokompikiswana kade khona ke la ngaphambi kwenkantolo ke athi khumbule khona njalo lana ke udaba lolu lukhona ke futhi lokuzana ama-facts lawo ke noma amaphuzu lawo ke bawabhalile lana ke ngaphakathi kwe-docket ke lapho ke futhi umbhalo wakhona ke noma bawumakhe ngokuthi u-A198 futhi ilanga lakhona ke kade kuyi-23 zenyanga ka-October ngomnyaka ka-2020 ke lapho ke athuma ngaba inkosi enkantolo yamvumela ke uyothi afunde ke lapho ke ukuthi ngabe yini iqokethiwe ngaphakathi kwe-statement leso sesamaphuzu.
Okay, my lord, it reads as follows. I, the undersigned, Bongani Nicholas Gininda, state under oath as follows. I'm employed as a police officer in terms of Section 30 of the South African Police Service Act 68 of 1995. I perform my duties under the same Act. I'm currently stationed at the National Commissioner's Office as the commander of the Cold Case Investigation Unit at the National Commissioner's Office with the rank of a colonel. And then it mentions the service number as well as my cell phone number, my lord. Paragraph 2 reads as follows. I'm the lead investigating officer of Phosphorus case 636 of 10/2014, which is a case of murder where one Senzo Meyiwa was shot and killed on the 26th of October 2014 between 20:30 and 2100 hours. The deceased was shot at the house belonging to then his girlfriend, namely Kelly Kumalo. It initially appeared that it was a robbery gone wrong. Witness statements under oath indicated that two black males entered the house demanding cell phones and money, purporting to be a house robbery. 7 adults and 1 child were present in the house when the accused entered. The witness stated that one of the accused was carrying a firearm purporting to be a revolver. This accused was described as a black male with big eyes, dreadlocks, wearing a khaki or brown jacket or top and a hat. He was shorter in height than the second accused. The second suspect was described as taller, slender, neatly shaven, and dark in complexion. It is stated under oath that during the robbery in the said house, a struggle ensued between Senzo Meyiwa, the deceased, and the suspect carrying the firearm. 2 shots were fired by the suspect. One of the gunshots hit the deceased Senzo Meyiwa on close range on his chest and exited at the back of his body. The second accused focused on the rest of the witnesses. In the process, one cellular phone belonging to Ms. Kelly Kumalo was robbed by the suspect during the committal of the offense. It is also stated under oath that suspicious suspects were wearing. It is also stated that suspicious suspects wearing specific clothing, amongst others a hoodie, were standing hidden away only few meters from the crime scene prior to the incident taking place, and on their cell phones. It is stated that the suspect fled on foot. The suspects fled on foot, and the hat which was worn by the shooter was left on the crime scene. It is equally stated that the suspect hidden away, which is explained to be linked to the offense, was seen running away from the crime scene. Identikits were compiled through witnesses of these suspects. The victim was rushed to the hospital by the witnesses who were in the house. However, he was declared dead on arrival at the hospital. The incident took place between 20:30 and 2100 hours. The deceased was declared dead on arrival at the hospital on 21:15. Paragraph 3. Investigation revealed that the cell phone which was robbed was picked up through a cell phone towers until the signal was lost, covering the area of Phosphorus area. The said cell phone was never recovered to date or even switched on again. The evidence explained hereunder will indicate that the planning of the offense and gathering after incident took place at Phosphorus Hostel. Investigations which resulted in evidence under oath revealed that the victim was murdered as a contractual assassination or hit rather than the robbery or robbery gone wrong. Evidence under oath revealed that 5 suspects actively participated in the planning and execution of the contractual murder of Senzo Meyiwa.
Thank you, hold it
No,
there.
please, let him finish. You asked the question, let him finish.
But my lord, I'm busy
No,
taking
no.
note as well.
Yeah, but you must say what he said in that affidavit.
But then when I'm going to take
You've got a
notes,
copy, Mr. Smith. You don't have a copy of that affidavit.
I don't have it before me.
Okay, I'll adjourn. Please make a copy for Mr. Smith.
Thank you.
Okay. Please.